Okay. All right. So my name is Caitlin Yazajoglu. I'm a solicitor here at DCLS. I'd like to begin by acknowledging the traditional custodians of the land on which we're meeting today, the Larrakia people, and pay respects to elders both past and present. And I extend that respect to all Aboriginal and Torres Strait Islander people here today. And I'd also just like to welcome you all to today's CPD session. So it's intended to be, bit of an introduction to unfair dismissals under the Fair Work Act. So it's not going to be totally comprehensive. The slides are definitely text heavy. I've done that deliberately with the intention of providing you a resource that will hopefully be a useful starting point in future. The slides will be distributed along with the link after today. So don't feel the need to digest everything on the slides. You'll get them later. All right, let's get cracking. So the Fair Work Act offers a number of different protections against wrongful termination. It doesn't offer blanket protections for all times, for all people. Certain conditions have to be met in order for people to bring an application for any of the protections, and unfair dismissal is no different. So we'll run through these in the course of the presentation. At a high level, unfair dismissal occurs when an employee is dismissed from their job in a manner which is harsh, unjust, or unreasonable, and where the dismissal was not consistent with the Small Business Fair Dismissal Code, if that's applicable, and is not a case of genuine redundancy. So don't worry too much about that definition just yet. It sort of sets the scene, though. You can see from the text that I've bolded that it's like a composite thing. So there's a couple of different criteria that need to be met in order for a claim to be successful. I think at the risk of stating the obvious, unfair in this context is different to how we might use that word if we're just having a chat with a friend over a coffee or something like that. And the reason I'm making that point is because I often find that when talking to clients, it can be a useful way of like explicitly acknowledging that even if their unfair dismissal case kind of legally has poor prospects, that doesn't necessarily invalidate their own experience and the feeling of kind of being aggrieved by what they see as unfair treatment by their employer. So it's just something to keep in mind, really. Claims for unfair dismissal are dealt with by the Fair Work Commission, and the Fair Work Commission aims to deal with these pretty quickly and efficiently. I've given you some stats there from the 2023-2024 annual report. So for their unfair dismissal cases, I think actually all cases, 82% of matters were finalised within 8 weeks. And of their whole applications, unfair dismissals accounted for 37% of those. So it's actually a significant portion of the Fair Work Commission's workload. The next highest was general protections, and that's only 14% of lodgements in the same period. All right, so we'll now look at some threshold issues like time frames and eligibility before moving on to some more substantive aspects of unfair dismissal. All right, time frames. Not very glamorous, but this is very, very important. So we're going to spend a little bit of time on it. A reasonable amount of clients come to us for help with an unfair dismissal claim, which is either just about out of time or is already, or they've already missed the boat. So we advise on extension of time type issues pretty regularly, and I expect that some of you are as well. 21 days isn't very long. Employees need to lodge a claim for unfair dismissal within 21 days after the dismissal took effect. That 21-day period doesn't include the day of dismissal. The clock starts ticking the next day. It is possible for a person to lodge an application out of time, but the Fair Work Commission can only accept it where it is satisfied that exceptional circumstances apply. Like I said on the slide, this is a really high bar. Just on the took effect point, took effect is actually not a defined term under the Act, but it basically just means when the employment relationship ended. Where it's kind of worth noting is that in a case where a person's employment has been terminated, but they've then been paid in lieu of notice, the dismissal takes effect like immediately rather than at the end of the notice period, because they've been paid instead of having that notice. And so the employment relationship has kind of already ended. All right, so let's look at late applications. So like I said, the Fair Work Commission does have discretion to accept late applications, but it can only do so where it's satisfied that extending the period, like that there were exceptional circumstances for not lodging the application on time. Exceptional circumstances are ones that are out of the ordinary course. They're unusual, they're special, they're uncommon. They don't need to be like rare, they don't need to be unique, and they don't need to be unprecedented. They just need to be sort of sufficiently unusual. There are a number of factors that the Fair Work Commission has to take into account when considering whether or not there are exceptional circumstances. These are set out in the Act, and you've got a list of them there on your screen. The first one is the reason for the delay. This is really important, and from a sort of bit of a survey of the cases, I think this is probably one of the most important ones. There has to be like a credible explanation for the entirety of the delay. That will weigh much more favourably in favour of a grant of the extension of time compared to a situation where there are chunks of time that are unaccounted for, or that the reason that's been given doesn't really explain. So, for instance, illness is a pretty common one. If you were trying to rely on illness as a reason for not being able to lodge your application on time, and you were, say, sick for 2 weeks, but the period of the delay was 5 weeks, I think probably the Fair Work Commission would be less inclined to accept that reason as being something that justified the entire period. The other thing to note with illness is it sort of has to be like a credible explanation that explains why you couldn't do the action of lodging the application. So, for instance, like a person might be suffering a period of mental illness or high distress, unless it actually is kind of a sufficient seriousness that it, or character, that it actually prevents a person from filing their application, then it might not be accepted as being a sufficient reason to justify an extension of time. Similarly, something like the shock and trauma of having your employment terminated, generally the Fair Work Commission will be inclined to find that that sort of shock and distress is not so incapacitating so as to justify an extension of time. One of the other important things to note when considering this factor is that if a person has contributed to the delay in some way, this will probably weigh against a finding of an extension of time. So another sort of species of reasons for delay is a representative error. So like where the lawyer hasn't lodged something or filed an application on time. The Commission will generally have regard to whether or not an applicant has in some way contributed to that delay. So there's a difference between, say, a scenario where an applicant might have given their lawyer instructions to file and go ahead with lodging an application, as opposed to a scenario where the lawyer has been trying to get instructions for a couple of weeks and hasn't been able to get hold of the applicant, and the failure to give instructions has therefore meant that the application has been delayed. So you can sort of see how this sort of contribution factor is taken quite, is unhelpful sometimes for an applicant who's wanting to allege that they were relying on on their representative to do something. Similarly, if an applicant's just like not followed something up with their representative, the Commission tends to take a pretty dim view of that. The next factor on that list is whether the former employee first became aware of the dismissal after it had taken effect. I'm not aware of too many recent cases that sort of deal with this, but you can sort of see a scenario where somebody was sent a letter, for instance, and there was a delay of, you know, somebody being dismissed and then receiving that in the post. So it might be a bit of a legacy one. I'm not sure how much that comes up in practice these days, but certainly still relevant. Next one on the list is any action taken by the former employee to dispute the dismissal. In some circumstances, like lodging an application sort of apparently for an unfair dismissal, but in the wrong jurisdiction, has been taken to be an act that, even though it was ultimately sort of futile, has been something where a person has been trying to dispute their dismissal. And so that has sort of been seen favourably by the Fair Work Commission. The same, or the reverse is also true. There's other cases where somebody's kind of filed in the wrong jurisdiction and, you know, because of inadvertence or an accident, but the Fair Work Commission has been less inclined to grant an extension of time. I think probably that point illustrates something that's really common through all of the cases around unfair dismissal, is that everything turns on its facts. The context and sort of the specific facts of the matter are really, really critical here. The next one is prejudice to the employer, including prejudice caused by the delay. Typically, there's a general presumption of prejudice where there's been a long delay. I think that's pretty standard generally. 5 days, you know, probably won't cause too much prejudice, whereas a delay of, say, 28 years is significant. That was a real application. It was Druitt and Rail Corporation in New South Wales. And obviously, after 28 years, it's pretty unlikely that anybody who was around at the time or is still there, documents might have been lost, that kind of thing. That's pretty significant prejudice, and that weighs quite heavily against a grant of an extension of time. Where prejudice is being relied on, though, it's up to the employer to produce evidence to show that there's prejudice, and then the employee can show that, in fact, the facts don't amount to prejudice at all. The next one is the merits of the application. Yeah, I might just deal with your question, Alicia, after I go through this merits of the application. For those who haven't seen, Alicia's put a question in the chat about whether the Fair Work Commission allows for like cultural background, language, lack of education issues, something along the lines of, I didn't realise I could apply for unfair dismissal. We'll just run through the rest of this list and then we'll come back to that one. Yeah, merits of the application. So this one's kind of a little bit of a funny one in that if you think about the type of information that the Commission has before them at this point in a proceeding, like where we're dealing with extension of time issues, it's pretty much just an application and possibly a response from the employer. We're not at the point where evidence has been filed, submissions have been made, that kind of thing. So any kind of assessment of merits has to be pretty light touch. The Commission generally will not and cannot embark on any kind of detailed consideration of the substantive case, particularly if there's like a genuinely contested matter, and if you're trying to look into things without the benefit of having any evidence before you. So they sort of do a bit of a light touch assessment of prospects. The final one is about fairness between a former employee and other persons in similar positions. This is basically just a point about precedent, trying to kind of standardise to a certain extent the approach across the jurisdiction. In terms of the question Alicia asked, so yes, all of the relevant circumstances need to be taken into account. No single factor is determinative. In circumstances where somebody could demonstrate that the reason that they had not made their application on time was because of any of these, like cultural background, language, lack of education factors, had been the reason for the delay, then it kind of slots into that first consideration. I think, though, it's a little bit, it's not always clear cut, because as a general proposition, ignorance of the timeframe for lodgement is not an exceptional circumstance in and of itself. But there are certainly ways in which the Commission can kind of take those things into consideration. There was a relatively recent case, Fantech, I think, and it dealt with a situation where a person was homeless for the most of that 21-day period and also had kind of a lack of access to technology. It's like a slightly different sort of set of factors to what Alicia was referring to. But in a similar way, the Commission actually did a reasonably good job of forensically going through each of these like confluence of events that had happened and went through how each of those might have factored into the reason for the delay. So in and of itself, cultural background might not get you over the line. Again, a lack of education issue might not get you over the line, but it's certainly relevant and can be persuasive. I hope that answers the question. It's all a weighing exercise, though. Okay, so hopefully you're all across timeframes. And so we might move on to the next bit. Who is eligible to make an application or a claim for unfair dismissal? So not everyone is protected against unfair dismissal at all times. I've bolded a few key concepts in that excerpt of the Act there. Relevantly, a person is protected from unfair dismissal at a time if at that time they're an employee, if they've completed a minimum period of employment of at least the minimum employment period, and one or more of those following apply, which is that a modern award covers the person, an enterprise agreement covers the person, or they don't have they have earnings that are less than the high income threshold. We'll sort of go through all these over the next couple of slides. The employee one is probably, I'll just get my PowerPoint working. Yeah. The employee one is pretty significant. You need to understand the nature of the relationship that this person has to their, employer or whatever the entity is they're trying to bring their claim against. I'm sure you're all aware, but employee is quite a different legal concept to, say, an independent contractor. The Fair Work Act and these kind of protections are limited to employees. I suppose contrast would be like work health safety law, where the person who is protected is a worker, which is a much broader kind of category of people than employee. So we need to understand exactly who the parties are and what the nature of their relationship is. I think in practical terms, this probably comes up a fair bit with like labour hire organisations. So you might need to examine whether a person is like employed outright or whether there's a third party who's involved, and if so, what the relationship is between all of those people. The next one is the minimum employment period. So a person needs to have completed a minimum period of employment with their employer before they can apply for the unfair dismissal, make their claim. Not all periods of employment are continuous service. So not everything counts. For small businesses, the minimum employment period is 12 months. For everybody else, it's 6 months. Whether or not a business is a small business or not depends on whether they've got less than 15 employees. That's just like a straight head count, and it includes casuals. And the relevant point of time to make that assessment is at the point where the person was dismissed. The continuous service thing can be really important. And so, like I said, not all periods count towards continuous service. And so not everything will feed into that minimum employment period. You might need to do some analysis if a person has taken like a bunch of leave, for instance, and the timing looks a little bit tight. Yeah, the Fair Work Act sort of defines what continuous service means and gives you some guidance about what is and is not continuous service. So it's sometimes just a process of going through and seeing and just like adding up the timeframes. Importantly, casuals can still meet the minimum employment period if they were a regular casual employee and had a reasonable expectation of continuing employment on a regular and systematic basis. Sorry, there's a bit of a typo there on the slide. So sort of, yeah, regular casuals, the same person you see, you know, every week at 4 o'clock or whatever, like that kind of like regularity and predictability is quite critical in determining whether or not a casual is or is not eligible for this protection. But yeah, it's sort of a bit of a myth that casuals aren't at all protected. The next myth that I want to deal with is the issue of probation. I think it's pretty common to hear people say, oh, yeah, I'm not eligible. I was on probation. Fair Work Act does not care about probation or not in this context. What is key is that employment period. Now, typically, a probation period is about 6 months anyway, in which case it's the time that's critical, not the fact that you were on probation or, you know, employed as in an ongoing way. Yeah. The next one is just about high income threshold. It's kind of a bit technical and not that fun to go through, but basically there's a high income threshold that's currently set at $175,000. Every year it gets adjusted. It's not just a matter of looking at somebody's payslip and being like, oh, yep, they're in or they're out, because earnings is a more expansive concept than that. The definition of earnings is set out in the Act, but it can include like non-monetary benefits, so like a car, but there's got to have been like a value of that kind of agreed by the parties or something that you can kind of figure out. Anything that's like intangible probably won't be an earning. For the same reason, anything that can't be calculated in advance, so like a performance-based bonus or a contingent payment, something where you have to do X, Y, and Z before you get this payment, probably isn't an earning because it's sort of not got that predictability of being able to be calculated before the payment has crystallized. Probably won't go any further into that. Okay, next criteria. There needs to be a dismissal. It sounds like a very obvious point to make, but the reality is it's not always clear-cut whether or not there has actually been a dismissal or whether something else has occurred. A claim cannot succeed if the Fair Work Commission is not satisfied that a person has been dismissed. What does dismissed mean? Okay, so dismissal describes a situation where a person's employment has been terminated at the employer's initiative or where the person has been forced to resign because of the conduct or course of conduct engaged in by the employer. There has to be an action by the employer that either intends to bring the employment relationship to an end or probably has that result. The question of whether the act of the employer results directly and consequentially on the termination is a really important consideration. It's not the only consideration. Like with everything else, you need to examine all of the circumstances, including the conduct of the employee. But nonetheless, that sort of like direct act is quite important. In terms of termination at the employer's initiative, this category sort of covers any situation where the action of the employer is like the principal contributing factor, which leads to the termination of the employment relationship. So it could be as simple as you're fired. It's got to be something that's not agreed to by the employee. So it can't be sort of a mutual termination of the employment arrangement. It can also occur where there's been a repudiation of the employment contract. So if an employer has basically abandoned its obligations under an employment contract, this doesn't necessarily immediately result in the termination of that contract. But what it can do is give rise to something which allows for a right to terminate the contract, which an employee might then do by resigning. In that case, even though the test for repudiation by the employer is whether or not the conduct showed in that case, the test is about whether or not the conduct of the employer showed an intention to no longer be bound by that contract. So something like Nora and Target. It could be something like failing to pay an employee, for instance. That's a pretty fundamental part of the contract. By refusing to do that, you have in part demonstrated an intention to not be bound by the terms of that contract, and it might give rise to the right to terminate the contract. In reality, there's a pretty significant overlap with this category and then the next one, which is about forced resignations. Forced resignations are where an employee has basically got no real choice but to resign. The case I put up on the slide is kind of the key one here. And in that case, an employee was pressured into resigning under the threat of being fired, basically. That conduct is actually picked up in the explanatory memorandum. It's a pretty old case, and so was kind of front of mind when that part of the Fair Work Act was being drafted. It's about sort of a response to unacceptable conduct by the employer. So again, this failure to fully pay wages. The line is a fine one. And the two cases that I put up there about Hobbs and then Bruce both deal with a circumstance where an employer has been less than great with paying wages that were owed. In one case, it was found that, yes, the employee had no real choice but to resign, and therefore it was a forced resignation. In the second case, it was held that even though the employer had, been a bit dodgy and often paid the wages a few days late, there were other options open to the employee, in which case they had other choices. If an employee is trying to say that they did not resign voluntarily and that they were forced into it, it's up to them to show that that's what happened. The next one is heat of the moment resignations. These ones are really interesting. Typically, as an employer, you are entitled to treat a clear and unambiguous resignation as just that, unless the resignation is given in the heat of the moment or otherwise in circumstances of such extreme pressure that these special circumstances arise, that basically means you should probably confirm whether or not the resignation was intentional. One of the key cases in this sort of sphere involved an employee who was called into a meeting to talk about allegations of misconduct. She'd prepared a resignation letter, which she then got upset in the course of the meeting and handed it over, but sort of scribbled on it and changed the notice period from 4 weeks to being kind of immediately. The employee was visibly distressed and upset. And then she tried to rescind her resignation the next day, and the employer said, no, you're no longer an employee. The finding in that case was that basically they were sort of put on notice that the resignation was not intentional, and that in those kinds of circumstances, a resignation might not actually be a resignation. And as an employee, you have to try harder, basically, to confirm what the status is. All right, what makes a dismissal unfair? Okay, so there are a lot of criteria that go into this. Section 385 of the Fair Work Act says that a person is considered to have been unfairly dismissed if the Fair Work Commission is satisfied that their dismissal was harsh, unjust, or unreasonable. So this is that definition that we looked at right at the very beginning. Also has to be satisfied that the dismissal was not consistent with the Small Business Fair Dismissal Code, if that's applicable, and that it was not a case of genuine redundancy. And we'll go through all these in turn. Section 387 of the Fair Work Act sets out the factors that must be taken into account when considering whether a dismissal was harsh, unjust, or unreasonable. Each of these criteria have to be considered. If there's a failure to do so, that's a jurisdictional error. Some of them are pretty self-explanatory, so we'll go through the juicier ones. The first one is whether or not there was a valid reason for dismissal related to the person's capacity or conduct, including whether or not it had an effect on this, health and safety and welfare of other employees. A valid reason for dismissal, or a reason for dismissal, will be treated as valid when it is sound, it is defensible, it is well-founded, it cannot be capricious, fanciful, spiteful, prejudiced, that kind of thing. There are a whole bunch of reasons that have been found valid. It's not the only criteria. Like I said, there's kind of a weighing exercise that happens. So it's quite possible that you would have a perfectly valid reason for dismissing somebody. For instance, if they were a threat to health and safety of other employees, but that your process was still, or that the dismissal was still harsh, unjust, or unreasonable. One that's pretty common is like a failure to comply with an employer's directions. So an employer has said, you must do this, and an employee has said no. Something like that can only be a valid reason for dismissal if the direction is lawful and reasonable to begin with. It came up a fair bit in COVID, like with COVID era dismissals, and generally speaking, where an employer was basically fulfilling kind of the health directions, the direction from the employer was considered to be lawful and reasonable. A kind of contrasting scenario is where a new policy was introduced. This is a 2019 case. A new policy got introduced that required employees to submit to fingerprint scanning to record people's attendance at work. An employee refused and then was dismissed. This was found not to be a valid reason because the direction itself failed to comply with Privacy Act and the requirements under the Privacy Act. So because the direction that was issued by the employer was not lawful and reasonable, failing to respond to it, failing to act on that direction was not considered to be a valid reason for dismissal. So you can see how sometimes you have to dig through a couple of layers of things in order to get to a valid reason. Interestingly, the reason doesn't necessarily have to be the one that's given by the employer at the time of the dismissal. Sometimes the reason kind of comes out after the fact. This is fine, but with the caveat that, like, it's not ideal. It's actually, not a great way to deal with your employees. But nonetheless, the Fair Work Commission has sort of found that that's not necessarily like determinative. Where it can trip an employer up, though, is if the employer's got no idea what the real reason is, because as you can see down the list, one of the factors is whether a person is notified of the reason for their dismissal and given an opportunity to respond. So yeah, it's a bit difficult for an employer to try and rely on a reason that was never put to an employee until after their dismissal. I think that the notification of reason and then the next one about opportunity to respond, these are classic procedural fairness requirements. Ideally, an employee should be notified of a proposal to terminate their employment before the decision has been made. At the very least, before the decision has been implemented. Because if you don't do that, then the requirement to give an employee the opportunity to respond has no work to do and no kind of practical effect. An employee should be allowed the opportunity to explain their capacity or conduct at all stages of the process, and that can include an opportunity to respond after like counselling sessions or warnings have been given, all before a decision to dismiss has been implemented. If the employee doesn't take up that opportunity to respond, that's fine. Really, the key issue here is whether or not the employer gave that opportunity to begin with. And again, any other matter that the Fair Work Commission considers relevant. This is obviously a bit of a catch-all, and it does exactly what it says on the box. Like the Fair Work Commission's got an extraordinary amount of latitude in what it can and what it can consider in this context. I think again that leads back to that point that I made earlier, that these cases really do turn on their own facts. So some of the same conduct in one circumstance might lead to a totally different outcome in a different matter. Context is critical, and the whole of the context is critical. You might recall that the next kind of aspect was about the Small Business Fair Dismissal Code. I'm not really going to go into too much detail about that. It picks up a lot on some concepts we've already discussed, but it does so in a modified form to permit a level of flexibility for small businesses. If a business has complied with the requirements of the code, then a dismissal will not be unfair. I've given you a link to that code in the resources section at the end of the slides, so that will get circulated as well if you want to have a look. It actually includes like a bit of a checklist, basically, to help people through that process. The next criteria is about genuine redundancy. So a dismissal will not be unfair if all of those other criteria are met, and also where it's not a case of, where there's not a genuine redundancy. If a person's dismissal is in fact a redundancy, then their dismissal will not be unfair. There's a few concepts in there. The explanatory memorandum provides some examples of changes to an enterprise's operational requirements of the character that sort of fit into understanding whether or not there's been a genuine redundancy or not. So section 389 sets out the definition. Person's dismissal is a case of genuine redundancy if the employer no longer requires the job to be performed because of changes in the operational requirements of the employer's enterprise, and the employer has complied with any obligation in a modern award or enterprise agreement to consult about the redundancy. Basically, this is designed to sort of capture scenarios where there is like a contraction of business, scenarios where a machine, for instance, might be available to do the job that was previously performed by an employee, where there's a downturn. And so where we previously needed 5 people to do a job or a task, now we only need 3, like restructuring to improve efficiency, and circumstances where like an employee's tasks might be distributed across a number of other employees, and so that job no longer exists, basically. In terms of the next, like section 389 1B about the consultation provisions, a failure, like it is important, but a failure to meet those consultation or redeployment obligations doesn't automatically mean that a dismissal is unfair. You still need to consider the circumstance as a whole. There is currently a case that's supposed to go to hearing in the High Court next week, Peabody, which is a mining company, and the whole case is kind of about these redeployment provisions. This is very much a watch this space kind of thing. Basically, there was the full court made a decision that a coal mine, like management of a coal mine, should have assessed whether or not 22 workers could replace some already engaged contractors before making these 22 workers redundant. They were made redundant in like mid-2020. So it's taken a while to go through all the processes. But yeah, the hearing is due to start in the High Court next week. And I think we'll get a little bit more clarity on what the redeployment obligation actually is once we find the outcome of that. Okay. The next, there's a neat little schematic from the Fair Work Commission's website, which just basically talks you through the life cycle of an unfair dismissal application. It's reasonably straightforward. I think as with most litigation, there's sort of the basic pattern of, application, response, conciliation, like ADR type phase, which in this case is conciliation conference. And then depending on what happens next, you potentially can resolve the matter and it all goes away, or there is some sort of arbitration that happens, not a particularly kind of unique process. Conciliation, I think, is really useful in this scenario. It's an opportunity to resolve for a much broader set of outcomes than what the Fair Work Commission can actually grant if you go the full way. I think it's pretty successful. Stuart's employment text, which is 2021, has some 2021 edition, has got some stats. Around 80% of matters are resolved at the conciliation stage or before it, which is pretty significant, particularly given you can resolve the matter, like conciliation happens in about 4 to 6 weeks. So you can resolve things pretty quickly. And so most things can be resolved pretty quickly, basically. There's another portion of about 12 to 15% that are resolved after conciliation, but before any formal decision has made. And I think you can kind of, group those together with the ADR, sort of the alternative dispute resolution success stories, I guess. Getting the parties in the room, even virtually, can be quite powerful. And I think there is a lot to be said for giving people the opportunity to have that facilitated discussion. And it seems that most of the time, the parties can work it out or work out something that's at least mutually acceptable, even if it's not ideal for everyone. I think a lot of employers take a pretty pragmatic approach to conciliation. There's been some criticism that this kind of setup kind of facilitates or encourages a bit of go away money, for want of a better term. But I think the reality is, like with any litigation, there is risk. And in responding to any litigation, you need to assess whether or not you want to take on the risk and potentially the effort and the cost associated with defending things to the hilt, or whether you want to come to some sort of agreement to resolve. Generally, only about 3% of matters go all the way to a ruling. And of those, about 50% are successful. So again, just because you decide to go all the way doesn't mean you'll be successful, I guess. So yeah, there's benefit to resolving at conciliation. If it's not resolved at conciliation or withdrawn, the matter can proceed to arbitration. There's sort of two ways of doing that. One is at like a conference, which is often in private and can result in a decision. It's a bit less formal than a hearing, and sometimes happens where both parties are represented. Where both parties are self-represented. If you've got representation, you're probably more likely to go to a hearing, which is conducted in public and again results in a decision. So potential remedies. The Fair Work Commission can order a remedy where it is satisfied that a person was protected from unfair dismissal at the time they were dismissed and that they've been unfairly dismissed. The grant of a remedy for an unfair dismissal is not automatic. There is a lot of discretion, and there are cases where the Fair Work Commission has made a finding that the dismissal was unfair, but nonetheless declined to order a remedy. So they haven't ordered reinstatement and they haven't ordered compensation. Those two remedies are basically the two that are available. Reinstatement is kind of supposed to be the top or the preferred type of remedy. I think in practice, though, it's pretty rare. I think only about 1 in 5 successful claimants are reinstated with their employers. I think that's probably just a reflection of how difficult it is to re-establish a working relationship once one is A, broken down, and B, the parties have had to go all the way to like a contested hearing because they weren't able to resolve it. I think at that point, trying to rebuild a like productive working relationship is pretty tricky. The key issue isn't whether or not it would be difficult or embarrassing or anything like that. It's about whether or not you can establish enough trust and confidence and like restore that viable and productive working relationship. If not, then compensation. The Fair Work Commission can only order compensation if it's satisfied that reinstatement is inappropriate and that it's satisfied compensation is appropriate in all the circumstances of the case. On the issue of compensation, you can't get compensation for everything. The Fair Work Act is like prescriptive about what can and cannot be considered in terms of, that final figure. So compensation can't be awarded for shock, distress, humiliation, that kind of thing. And there are sort of some factors that the Fair Work Commission has to take into account when coming to a figure. So anything that the person has earned since they've been dismissed, as well as any kind of earnings from work that they would have otherwise had they not been dismissed, are relevant. Compensation is capped. So it's currently capped at $87,500. I don't know of any cases off the top of my head where an applicant has actually gotten that much. It would be extraordinarily rare to reach the cap for compensation. It's typically much, much lower than that. The actions of an applicant may or may not cause a reduction in an award of compensation. So if you've engaged in misconduct, for instance, then the amount of compensation might be reduced. Again, if you fail to mitigate your own losses, so for instance, if you have not attempted to find new employment, something like that, then that could also see a reduction in the amount of compensation that you get. I think that probably takes us to pretty much the end. There's a couple of resources on your screen, but again, those links will be circulated, so don't worry too much about it. I think that takes us to the end. You must all be absolutely sick of hearing the sound of my voice. I know I am. Is there any other questions? can't see any hands up, and it doesn't look like there's any more questions in the chat. So yeah, sorry for ranting at you for a whole hour, but hopefully that gave you a bit of a rundown, and that you can all sort of, yeah, feel like you now know a little bit more about the key concepts. Right, well, if there's no questions, maybe you can all get an extra 5 minutes of lunch. Thanks, everyone.